Hello, hello, hello. Is anybody here? Is anybody here? Say hi in the comment. Is anybody here? Say hi in the comment. We are going to wait a little bit for people to get in. Anybody here? Say hi in the comment. We're going to talk about motion to reopen. All about motions to reopen. Anybody here? Say hi in the comment. It is 5 p.m. Eastern Time. Anybody here? Hello, hello. Say hi in the comment. We're going to wait for 5 more minutes and I'm going to get started. You can watch it later. So if you're not here, you can still watch it later, okay? You can still watch it later. Anybody here? Okay, so let me share my screen so I can get started. You can actually catch up, share screen. Okay, so we're going to talk about motion to reopen, right? Motion to reopen, okay? The first thing is, why are you filing for a motion to reopen? You're filing for it because you would like to present new evidence and getting a new decision on a different factual record or on change in law. You want to file it because you have new evidence, and those evidence are material and they were not available and could not have been discovered or presented at the former hearing. You want to file it for the purpose of showing eligibility for relief. Okay, if you want to file it for the purpose of showing eligibility for relief, you must show prima facie eligibility for relief. Okay, for example, let's say somebody wants to file a motion to reopen because they want to adjust status based on the I-130 approval. Okay, now they can show their I-130 approval. That's prima facie eligibility. Okay, the notice of approval, or maybe they want to file this motion to reopen because they want to show that they have an I-360, a VAWA petition approval notice. Okay, that's prima facie eligibility. One thing to keep in mind is that the law guarantees to each non-citizen the right to file a motion to reopen. So you have the right to file a motion to reopen. Okay. So if we go to the next slide, when should you file a motion to reopen? Okay, we're talking about bars to filing a motion to reopen. You might file within 90 days of the final removal order. If you file within 90 days, you can only file one motion. That's why it's so important when you're filing within 90 days, within that deadline, you get all your facts straight. Well, and then there's a departure bar, reinstatement bar, 10-year bar to certain relief in absentia orders. This means that if, let's say for this one, number 5, right? Let's say somebody has been ordered removed and the person was not present. They failed to appear in court and they never show good cause, then they are barred for 10 years from adjusting status. Certain relief for failure to comply with voluntary departure. They give you voluntary departure and you fail to comply, well, you have a 10 years bar prior to filing a motion to reopen. You have to comply with voluntary prior frivolous asylum finding bar. If you have a frivolous asylum application and, well, unfortunately you bar to reopen your case because you still have to address that frivolous application. Okay, sorry. Here, inadmissibility ground triggered by departure. Okay, so exception to the time and number of bar. When should you file a motion if you're filing it after 90 days? How do you do it? You join motion to reopen. This is when you ask ICE to join you in the motion so that you can reopen your case. Or you just ask the judge to reopen because the judge has authority to reopen the case too, right? You're seeking reopening to apply for asylum based on changed country conditions, okay? Equitable tolling. This one is, you want to toll this deadline because you have reasons. We're going to talk about it later on. Seeking reopening based on Violence Against Women Act. You became eligible because you have a VAWA petition approved, okay? Yeah, so for joint motion to reopen, there's no time or number limit. You can file as many as you can, as long as you're really providing new facts, new evidence. Joint motion are possible, but only be granted in narrow circumstances because DHS is not looking to add to the docket. So when you joining ICE to join the motion so that they can reopen your case, well, just know that it's not their priority, right? It's because it's not their priority. Well, they can take as much time as they need. That's the challenge. You see, that's the challenge. So if they're not responding really, you can just do sua ponte and ask the judge to decide. It'd be nice if they join, but if they don't, what are you gonna do, right? You just go sua ponte and ask the judge. PD requests often granted where an individual is eligible for relief before USCIS. Prosecutorial discretion. When somebody is eligible, they file a joint motion to reopen and dismiss the case, or a joint motion to reopen and then joint motion to dismiss. Okay. If joint motion to reopen pursue without dismissal, then the party may still contest the issue in the reopening proceedings. Let's say that you're not trying to dismiss the case, but you want a new decision on your asylum petition, for example. Then you are reopening so that you can have the opportunity to argue again, okay? Especially if you're filing, we're gonna go into it later on, if you're filing for, based on the, let's say, ineffective assistance of counsel, right? Because they didn't argue your case well, so you have been prejudiced. And then when you reopen, it's because you want the opportunity to argue again. So basically, that's why you're reopening. Sua ponte, this is when the immigration judge, they may open the case at any time. What are the reasons you're filing for sua ponte motion? Ineffective assistance of counsel or due process violation. They violated your due process of law, well, you can reopen sua ponte. Ineffective assistance of counsel, you can reopen sua ponte. But with ineffective assistance of counsel, it's a little bit challenging because you have to prove that you meet those requirements procedurally and substantively. So procedurally, basically, you have tried to talk, you have the agreement, right? You state what the actual agreement said. You went ahead and talked to the counsel who argued your case. You give them the opportunity to respond. Then you file a complaint with the bar. And if you didn't file a complaint, you have to tell them why you didn't file. That's the procedure part. Substantial part is when you really want to say why you think the assistance was ineffective. Maybe because they violated your process, due process of law, which means, for example, you went to court and the lawyer waived all your rights without you knowing. That's violation of due process of law. Or maybe their representation was so ineffective that the judge had no option but to deny your case. Or maybe the lawyer, because of the lawyer, you missed the deadline. You relied on counsel, and because of them, you missed the deadline. Ineffective assistance of counsel. So you can change, you can ask for sua ponte when there's change in law, right? When you want to talk about your claim to U.S. citizenship, like you want to argue about your claim. You want to acquire lawful status. You want to pursue previously unavailable relief. Okay? And then, yeah. So just be in mind, keep in mind that if this one gets denied, you have limited opportunity to appeal, in federal court. Okay, limited opportunity. You can appeal, but so limited. While equitable tolling is when you're really asking that they have to not go with the deadline, the 90 days deadline, because of specific reason. For example, they can toll a deadline, but the individual must show that they have been pursuing their right diligently, and some extraordinary circumstances stood in the way of timely filing. For example, serious illness, coma, car accident, education level, lack of education level, lack of English fluency, lack of legal knowledge, lack of access to resources, inability to afford an attorney, mental illness. Those are the reasons where you can tell the judge you missed the deadline because of those reasons. But you have to show that you were trying to get things right. But unfortunately, based on extraordinary circumstances, you couldn't file on time within that 90 days period of time. Okay. And then we have in absentia motion to reopen. That's for failure to appear in court. Okay. But you can show that you want to reopen the case because you did not really fail to appear in court. Maybe you got into a car accident. Maybe they did not properly serve you with a notice to appear, never received the notice. DHS did not meet burden of proof, lack of notice. Yeah, you did not receive the notice, exceptional circumstances, okay? And then we have other type of motion to reopen, previously unavailable relief. Okay. So, I want to go to the next slide. Okay. How can you rescind and reopen an in absentia order, like you were not in court and the order you remove and you want to reopen it? You have to do it within 180 days, within 6 months, okay? And you have to demonstrate that the failure to appear was because of exceptional circumstances. But if you reopen at any time, you can show that you did not receive notice, or you were in federal custody. Let's say you were in prison or in jail. You couldn't really appear in court, so you can reopen that case anytime. So you can go and argue, okay? So, well, if the immigration judge denies your motion to reopen, then you can appeal it within 30 days to BIA. If you BIA deny, you can appeal it to the circuit court within 30 days. But when it comes to federal court, some jurisdiction has limitation, okay? So you have to keep this one in mind. Last thing is, Motion to reopen based on change country condition. There's no time limit. There's no numerical limitation. You can use change personal circumstances to show change country condition. If somebody wants to reopen their case based on change country conditions, yeah, they need to contact me so we can figure this thing out. Okay. Then we have post-departure motion to reopen. It's basically when somebody has been ordered removed and they left the country and now they want to reopen their case. It really depends on circuit, okay? The 8th Circuit does not agree with jurisdiction, but some other circuits you can argue, okay? Now it's time for questions. Stop sharing. We're going to take questions now. Let me take questions. Yes, so it's time for questions. I don't know why people were not entering. So, but it's time for questions. I don't know what went wrong with this webinar. You can watch it later, but it's time for questions. Yes. Vimala Trikaya. Okay. Can you file a motion to reopen because the previous lawyer didn't do the proper job? Yes, that you can file it. There's no deadline for it. You can file it with the court directly. Sua ponte, like you send your motion to the court and you serve ICE. However, there are certain requirements that you have to meet first. First of all, you have to have the agreement. You have to talk to the lawyer and give them the responsibility, like the time to respond. Then you file a complaint with the bar, the association. If you don't file a complaint, you have to tell them why you didn't file a complaint. So you have to tell them why you didn't file a complaint. And then you file. And then you really tell the immigration court why you were filing this motion, what exactly they were supposed to do and what they didn't do. So, yep, that's what you should do. I guess I hope I answer your question. I'm trying to see if something went wrong. Did you, Vimala Trikahaiti, did you get a problem logging in? Let me know in the comment if you got a problem logging in. Because I don't see why other people got okay, thanks for letting me know. Okay, let me get another question. During the trial, the judge waived the 1 year issue because we were scammed by a paralegal, but our lawyer forgot to ask written paper for the waiver, and after the case was pending 3 years, the 60-year-old judge forgot and said it was more than a year. Oh, so your lawyer forgot to file the paper for the waiver. This is major. You can reopen your case based on ineffective assistance of counsel. So if the lawyer forgot to the deadline, so basically the lawyer missed the deadline. So yeah, as I was saying, you have to go back, look at the agreement, basically tell like what you actually agree as a job for the lawyer to do. Then tell them that they didn't do their job. Give them the opportunity to respond. Sorry, 2 weeks is enough. After that, you file a complaint with the bar, the association. If you're not filing a complaint, you have to say why, and then you can go back to court really and ask them to reopen based on ineffective assistance of counsel. Okay, thanks. Auntie Ayuk to Kim, do you have a question? Because we already went through the presentation, so I just want to know if anybody had a problem logging in. So, okay, yes, your lawyer forgot and kind of push to take the 10 status instead of arguing to the judge. Can we do consultation with you if this case is doable for motion to reopen? Yes, you can do a consultation to find out whether this case is doable for motion to reopen, but what I'm saying is that you have to go through the proper procedure first. You need to have the agreement and say what exactly was supposed to be done. Talk to the lawyer and tell them that they mess up. And then file a complaint with the bar. You have to do those 3 things first. But if you want to do a consultation, that's fine with me. You can always do a consultation. Okay. Thank you. Yeah, for your case, what is the normal processing time for MTR? Okay, Takim. Well, it depends. The normal processing time is 90 days. Okay. But if you miss the deadline, then you have to have exceptions. And you can go back and rewatch this video. You'll see the exceptions. For example, ineffective assistance of counsel, change in country conditions, or you want to just status based on an approved petition, you can always try to reopen. Okay. So I'm trying to find out if somebody had a problem with logging in. Yeah, in the meantime, if anybody has a question, they can just put it in the comment. I'm just trying to find out if somebody had a problem logging in. So let me go back. Okay. Okay, I guess nobody had a problem logging in. So yeah, I guess nobody had a problem logging in. Yeah, we're just gonna, like, if there's no more questions, I'm just gonna like end this live session. You can go back and watch the video again. So is anybody, oh, this is the person here. I don't know if a person want to ask a live question. Oh no, okay. So yeah, that's it. That's it, right? For today, we wanted to help somebody if they have a case to reopen their their case, file a motion. Please email me. Email me. I can send you a link for consultation so you can schedule a consultation. Okay, so okay, you say it's for your brother. I lost connection just now. Okay, if the case is doable for motion to reopen, it's for my brother. I did motion as an I-360, but not sure if it's safe to reopen without family petition for my brother. I-360, okay. Well, was the I-360 approved? Yeah, that's the problem. You need to ask yourself, was the I-360 approved? If you have an approved petition, yes. Let me send you the link. Let's do this. Let me send you the link so we can talk about it in a consultation, okay? So let me send you the link. Oh, okay. You want to reopen. I-360 is for you. Okay. And you are a resident. Oh, okay. You already adjust your status. Okay. You want to reopen for your brother. Yeah, your brother has to do those 3 steps. They need to know what the lawyer was supposed to do. They need to talk to the lawyer and see the lawyer messed up. Then give the lawyer the opportunity to respond. And once the lawyer responds, then really, once the lawyer responds, then they can file a complaint with the bar, then reopen the case. So I send you the link. You can schedule a consultation. Okay. So any more question? I need to take one last question so we can. Oh, okay. I saw the question here. Sorry. Let me answer this question. Okay. I-60A. Yes, you can file a I-60A because I-60A USCIS has jurisdiction, right? So you can file I-60A. And are you reopening based on what, basically? Is there any new fact? Is there any new fact? Yeah, I'm trying to get Takim question. Why would you want to reopen the case? Based on what? That's what I want to know before I hang up today. Why would you want to reopen your case? Takim. Oh, okay. Adjusting status ban on I-130. Is it I-130 approved? Okay. Is it for spouse or child? U.S. child or spouse? U.S. spouse. I guess it's a U.S. LPR, like lawful permanent resident. Spouse. Okay, and your spouse is a lawful permanent resident? Or a U.S. citizen? Because why would you need the I-601A? Probably your spouse is a lawful permanent resident. So, okay, Takim, this is how it goes, right? If you're a citizen, then you don't need a I-60A. Why would you need I-60A? So basically, this is how you're gonna play it, right? You're gonna reopen your case based on adjusting status. You're gonna try to join ICE to reopen your case because you have I-130 petition approved from a U.S. citizen, okay? And we have to know, first of all, why you were ordered removed. So if you were ordered removed because asylum didn't work out, then you should be good. No criminal record, you should be good to reopen the case. And this is the time when the climate is good. So yeah, let me send you the link for consultation. You pretty much, yeah, you are in the good to reopen your case, to be honest with you, Takim. You can reopen your case, okay? U.S. citizen spouse, you can reopen your case. If then we can adjust status. I don't know if you why you need the I-601A. Did you enter without inspection? Because if it's just about unlawful presence, you don't need the I-601A if the wife is a U.S. citizen. You don't need it. So anyway, so well, I guess we got it. I'm gonna try to post it on YouTube later, so that some other people can. I don't know if some other people had the problem with this, but I'm gonna post it this weekend on YouTube so that other people can see it. Okay. So until next time, bye-bye. I guess I got all the questions. You have the links. If you need a consultation, you can just schedule it. Until next time, bye-bye. Thanks for joining, by the way. Thanks for joining. Okay. Okay, previous asylum filed and then pending I-485. Yes, if you have a pending I-485 with USCIS, they're not going to adjust it for you. They're not, because you're still in removal. You still have an order of deportation. It's really difficult to convince USCIS that you have they have jurisdiction. So the better way to go about it is to really close your case, reopen, terminate removal proceeding, then take that order of termination and send it to USCIS. That's how you're gonna do it. So, because if you're gonna wait for USCIS, and at some point they're just gonna close the case, administratively closing the case. And even if they don't administratively close the case, what's gonna happen is, even if they give you a green card, you can't do nothing with it, because the moment you travel to come back, they're gonna put you back again in removal. So it's just better to reopen the case, terminate, take that motion to terminate, send it to USCIS where your I-485 is pending. Okay. Thank you very much for joining. I'm gonna post this video later on YouTube because I guess some people had problem logging in. I don't know why, but anyway, I'm gonna post it on YouTube so that everybody can get a chance. Okay. Thank you very much. Talk to you later. Bye-bye.